Welcome to this second season of Altea Talks, the dedicated podcast being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm your host, Will Marshall, and I'll again be joined in this second series by some of the leading figures from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging, and rewarding of sectors, then look no further because you're in the right place. Welcome again to Altea Talks. Hello and welcome to this latest episode of Altea Talks. I'm delighted this episode to be in Dublin and to be joined by Aislinn O'Shea, a leading lawyer at Mason Hayes and Curran, the top healthcare firm based in Dublin. Aislinn trained and originally worked in a boutique medical negligence firm called Doyle Solicitors in Cork, where she worked for an array of healthcare clients. She started working in Mason Hayes and Curran in Dublin in the area of medical negligence in 2019. Mason Hayes and Curran is a top-ranking law firm in Ireland, and it has the largest healthcare team in the Republic of Ireland. The team is drawn from specialists across the firm and is comprised of lawyers having backgrounds in industry, science, and medicine. The firm advises a wide variety of organisations involved in the provision and development of healthcare services and other businesses which support the healthcare sector. Aislinn herself has been practising in the area of medical negligence, where she assists and supports public and private clients through what are, more often than not, complex, emotive and difficult litigation for all involved. Her practice ranges from assisting clients in routine medical issues which arise during their practice, all the way through to high-value, complex, catastrophic injury claims. Aislinn has a special interest in corporate healthcare, home care, neurosurgical claims, and cervical cancer claims. She's an expert in the area of urgent delayed diagnosis claims, which are often fast-tracked and case managed by the courts due to the plaintiff's terminal diagnosis. Aislinn is interested in practice and procedure before the courts and is an advocate for fair procedure, particularly when there's been a delay in proceedings being advanced. These lengthy proceedings can be very difficult for practitioners and insurers, and they can lead to prejudice. Aislinn has successfully had many cases discontinued and dismissed due to delay, and this is going to be a topic we're going to be talking about today. In particular, she was directly involved in the landmark decision in Ireland of Rooney v HSE, where she acted for the defendant and succeeded in getting a medical negligence case dismissed on the grounds of excessive delay. Aislinn, a very warm welcome to Altea Talks.
Great to see you and welcome to Ireland.
It's an absolute pleasure to be back in Dublin, and thank you again for agreeing to appear on the podcast. In today's episode, I would like us to focus on three specific areas which I understand are very topical in the Irish healthcare litigation space at the moment. Firstly, an area which I know is close to your heart, which is the new practice directions that have come in to help the courts manage medical negligence litigation more efficiently and effectively. Secondly, I'd like to talk to you about the non-surgical cosmetic sector and what the landscape's looking like in the Republic of Ireland. And thirdly, I'd like to touch on the domiciliary care sector, where I understand there is proposed new regulation that is going to impact significantly on that sector. So I hope those three topics are okay. And we may as well dive straight in and look, first of all, at an area which I know, as I said, is something that is very close to your heart and something you're involved in your professional, day-to-day professional practice, and that's the new practice directions. And without getting too technical, I understand that these are practice directions HC 131 and HC 132, and I see they're being described as a major leap forward in the management of clinical negligence claims in the Republic of Ireland. Aislinn, can you walk us through what has prompted these changes and why is now the right time for their introduction?
So in Ireland, clinical negligence cases take a lot of time to resolve. It could be 3 or 4 years. So the courts recently introduced the practice directions and they came into place on the 28th of April this year. Before this, parties might be waiting approximately a year for a trial date. As you were waiting a year for a trial date, a lot of the procedural steps wouldn't have been carried out. So there'd be time to do it right before trial. Then what might happen is that the procedural steps are all carried out right before trial. And then there might be an application to adjourn the case or vacate the trial date. As these steps were being carried out right before trial and the trial date might be vacated, there'll be a slot in the court system and a judge will be available for a trial date. But because a trial date might be pulled out at last minute, then there wouldn't be another case to slot into that trial date. And that would mean that the court's time might be wasted. And this was an inefficient use of the court's time. So the practice directions front load the work so that a lot of the procedural steps will have to be done before you even apply for a trial date. Then generally in clinical negligence cases, courts don't apply timetables for the parties to carry out certain procedural steps. But this was available for certain cases, for example, fast-track cases where a patient might have a limited life expectancy or be terminally ill. Then the court would apply timelines to carry out procedural steps. That meant that cases were being dealt with very efficiently and it worked really, really well. And now the new practice directions actually make this available to all clinical negligence claims, which is great and is going to make claims resolve much more efficiently and resolve much earlier than usual.
Yeah, so the fast track cases showed that it could be done.
Exactly, that's it.
Yeah. Well, I mean, it just seems to me that that's a logical approach to it, really. To leave everything until the last minute, and so you're having to vacate a trial date. That must result in significant additional cost for the litigating parties as well.
Yeah, exactly. So both parties would have prepared for trial right up until, the date is vacated. Experts would be on standby. They'd charge us fees because they'll have to take time out of their work schedule. And then if the case doesn't go to trial, we still incur all of these costs and you have to go through it all over again when you prepare for the new trial date. So this definitely increased legal costs, and hopefully now with the new practice directions, as most of these procedural steps will be carried out before you even apply for the trial date, this should reduce costs.
Yeah. Okay. Well, that's great. And I understand that one of the standout changes is the creation of a new dedicated clinical negligence list. How is that going to operate in practice? And what impact do you think that having a dedicated list will have on the speed and structure of really managing clinical negligence proceedings?
So the principal purpose and objective of the practice direction is to facilitate the early resolution of claims while also ensuring that the cases are properly prepared for trial and enhancing efficient case management generally. As I mentioned already, clinical negligence cases were generally slow to progress. So now we have a new special clinical negligence list, which means we'll have dedicated clinical negligence judges dealing with that list. So then this list will operate that cases involving clinical negligence, or you can go before a clinical negligence judge on the clinical negligence list and they would hear applications for trial dates, interlocutory motions and smaller mentions, but they won't deal with common law motions. So common law motions would include motions for discovery of a plaintiff's records or a motion for a defence. It also remained to be seen what other kind of directions a clinical negligence judge might direct. I'd expect that the judges might start tailoring orders and directions to clinical negligence cases. And I'd say both parties, defendants and plaintiffs, will have to adapt to that. So it'll take time to navigate and process that, if that ends up being the case.
Yeah, thank you. And these dedicated clinical negligence judges, are they going to hear the substantive trial at the end of the process, or are they just the procedural judges who will deal with the sort of interlocutory motions and things? Do you know?
No, I don't know off the top of my head. Sorry. I think they do, but I'm not too sure. Yeah. I'll have to go back and check.
Yeah, no, it's just the reason I ask is that in England, in the High Court, there are assigned procedural judges called masters, and there's a couple of clin neg ones. So they're sort of they're very used to hearing things like, I don't know, applications about expert medical evidence and that sort of thing. But that's not necessarily who you get as your trial judge.
Yeah. Previously, there was just a general list. So if you had any procedural matters to be dealt with before trial, you just went into a judge who may not have clinical negligence experience. So they mightn't be used to dealing with those applications, though, because you could appear before any judge, they all tend to have experience in everything, but they wouldn't be as specialist in clinical negligence.
Yeah, and it's a very specialist area, isn't it?
Yeah.
So you've talked a bit about the importance of the timing of applying for a trial date. And I understand that the new practice direction lays out quite a structured process for when that can be done. And I understand it's absolutely critical, really, to the efficient management of these cases. Can you explain the key requirements that parties now have to meet before a case can proceed to trial? And also give a bit of an overview of how this might change the litigation culture in medical negligence cases in Ireland?
Yeah, so the practice direction lists a lot of requirements that need to be dealt with before a party applies for a trial date. Now, a court can dispense of any of those requirements. I won't go into every single one of them. We have an article on the website if you want to see. But the main ones actually are, so an applicant must provide an undertaking to offer mediation. One of the main ones also is that all final pleadings must be served before you make an application for a trial date. This is really, really important. I think it'll make a huge difference. For example, a plaintiff will have to deliver a fully complete and vouched schedule of special damages. So this is a legal document which lists out-of-pocket past and future expenses, for example, loss of earnings. Sometimes if this is delivered very late in the day, a defendant may not have enough time prior to trial to consider and investigate and obtain expert reports if necessary. And sometimes this may lead to insurers needing to adjust the reserve last minute, which isn't ideal. Also, on the other side, amended defences will need to be delivered in advance of trial. Sometimes what might happen is a defence would be amended right before trial, and it could include new specific pleas which the plaintiff will need time to consider and investigate. And then what could happen is that there'd be an application to adjourn or vacate the trial date. Also, as particulars of negligence will need to be delivered before you apply for a trial date, that means it should be settled what the issues are between the parties. What sometimes happened in the past was there'd be particulars of negligence delivered very late in the day prior to trial. These last minute allegations would need input from healthcare practitioners in the lead up to trial to get their input on the new allegations. During this time, healthcare practitioners are already nervous in the lead up to trial, and then there's a new allegation that they need to consider. Sometimes then, if these new particulars of negligence are delivered, sometimes a court might actually adjourn the trial, and then we're into the situation again where there's a slot of a trial date, left empty, which can't be filled by another case. So the practice direction should avoid a lot of that going forward, all going well. And then one of the other main things that a party must do before they apply for a trial date is to offer an exchange of reports. And this is important because when expert reports are exchanged, the parties often figure out where some weaknesses are and the strengths are of the case, and narrows the issues between the parties. Then these new practice directions, they'll likely lead to earlier resolution of claims, as mediation will be taking place earlier. This will narrow the issues between the parties. For example, what might happen is at mediation, the parties might realise that the experts are in agreement about how much the loss of earnings claim is. So the parties might agree what the loss of earnings claim, and then the plaintiff's expert on vocation and also the defendant's expert don't need to attend trial. So then you're avoiding legal costs and saving the court's time when that issue doesn't have to be dealt with before the court.
And presumably you're making the case easier to settle as well, because you're narrowing the issues between the parties and you're seeing where the consensus is. And it's more of a sort of cards on the table approach, isn't it? And really sort of making the parties be more transparent about their cases.
Yeah, because often what would happen when we exchange expert reports is we might see something in the plaintiff's reports which to us may be a bigger vulnerability, but we didn't think was as big a vulnerability because there wasn't as much detail in the pleadings. So an earlier exchange of reports often leads to an earlier resolution because it can show a defendant the weaknesses of the case, but also the strengths of the case. Sometimes plaintiffs might discontinue when they see your reports, and a doctor and an expert doctor might explain what actually happened. And sometimes this is useful for a plaintiff client to see so that they consider if they should discontinue the case.
And a lot of emphasis on mediation. It's a major focus of the new practice directions, with, it seems to me, an explicit expectation that parties should engage in mediation in good faith as a matter of course. How much mediation do you see in your clinical negligence practice, and how do you see this promotion of mediation, express promotion of mediation in the practice direction, influencing the resolution of claims outside of the courtroom?
Yeah, so in Ireland, in clinical negligence cases, actually a good proportion of cases actually resolved by mediation. Now with this new practice direction, I would say a lot more mediations will take place. But what's actually important is the parties don't have to go to mediation if there's not a good reason to. But I expect a cohort of claims will likely be very limited, even where a defendant might be, at the moment decide that they want to go to trial and fully defend the case. Sometimes mediation can be helpful because sometimes something might be revealed that you hadn't prepared for. And it's good to know that at an earlier stage rather than at trial when everything's unraveling and falling apart then at that stage.
Looking ahead, how do you think these practice directions are going to affect some of the key stakeholders in these cases? Healthcare providers, their insurers, legal practitioners such as yourselves, and I guess also plaintiffs, particularly in terms of compliance and overall case strategy.
In general as well, as I mentioned previously, cases are going to resolve much earlier, which is a very welcome change, hopefully. And this will alleviate a lot of angst that's often suffered by healthcare practitioners in the lead up to trial. So for insurers, the new practice directions will lead to the earlier resolution of claims, and therefore there should be savings in legal costs. Also for insurers, reserves, which is the amount that they set aside in order to pay for damages and legal costs, won't be tied up for as long a period as previously. Before, clinical negligence cases often lasted a couple of years, so the reserves won't be tied up for that period of time if the case resolves earlier because of this new practice direction. Also, schedules of special damages are delivered earlier. That means reserves can be fine-tuned earlier, which again will bring earlier certainty to reserves.
Yeah, of course. And the schedule of special damages is the document that the plaintiff has to prepare that really costs out their case, isn't it?
Yeah, so that's a document which will list out their out-of-pocket past and future expenses, and it helps a defendant, quantify how much the case might ultimately settle or a court might award so that they can set that money aside.
Yeah, and what do you think of the sort of main, I mean, you've talked about this a bit, but what are the main sort of implications for you as a legal practitioner?
Yeah, so it'll just mean a lot of front loading of work for cases, which is good because often when things are left to the very last minute right before trial, everyone's rushing and you might have difficulty getting experts last minute. So this front loading will make a huge difference, hopefully. Though what might happen now with these new practice directions is, let's say, for example, a plaintiff might apply for a trial date and then, over a number of weeks might comply with all of the requirements. And then the defendant is reacting to that, and there might be new allegations that need to be considered. And a court might set a trial date, and hopefully the court will consider that a defendant will need to carry out further investigations. And sometimes maybe it might be the case that we might not have as much time as we would like to carry out those investigations if there's new allegations.
Yes, you might have a timetable that is potentially unrealistic, that doesn't give you enough time to respond to all of the new allegations that are being put forward. I can see that. But generally speaking, it seems to me that this is a step that it's a welcome step really for all parties, isn't it?
Yeah,
because
definitely.
It's bringing some structure, it's bringing some proactive case management by the courts into the system. And hopefully that will have a positive impact on transparency and ultimately getting to the final answer quicker.
Yeah, exactly.
And it's a question of sort of being a fairer outcome and a more proportionate process to get there. Yeah. Thank you. It's very interesting. Well, we'll watch this space. Maybe we'll come back and talk to you in 12 months or so when you've been working with it to see how enthusiastic you still are about it. But I'd like to just move the discussion on now, Aislinn, if that's okay, and talk briefly about the aesthetics sector, and in particular the non-surgical aesthetics sector, because I understand that in Ireland, as in many other countries, this is a booming sector in terms of popularity, in terms of the number of participants, the number of people providing the treatments, the variety and range of treatments changing all the time. And as such, it's whilst it's great to have a booming sector and to have such a popular addition to our high streets, it does raise a bit of a challenge, let's say, for the regulators and for the lawmakers to keep pace. So can I just ask this to kick off this section? What legal frameworks currently govern the administration of Botox-type treatments in Ireland?
So in Ireland, Botox-type treatments can only be administered by medical doctors or dentists or nurses under the supervision of a doctor or dentist. So Botox-type products is a prescription-only drug. So a doctor or dentist would have to draw up a prescription. I understand that this is different to the rules of administration of Botox-type products in the UK, and that's caused a bit of confusion in Ireland. An example of this was a case where a nurse from Northern Ireland who administered Botox-type products to patients in the Republic of Ireland was suspended for 3 months by the UK's Nursing and Midwifery Council. She'd only started working in aesthetics treatments at the time. So she was registered as a nurse in the UK, but not in Ireland. So she wasn't authorised to administer Botox-type products in Ireland. She had prescriptions for the patients, but the medications she was using had UK licensing numbers, so they were not legally on the market in the Republic of Ireland.
All right. So you have to be a registered medical professional or a registered nurse to administer Botox in Ireland.
That's it. Yeah.
Right. That is different from the UK. And to what extent, well, you may not know the answer to this, but is there an issue, a wider issue in Ireland of Botox being administered by people who are not appropriately regulated or registered to do that?
Yeah, so there was actually an investigative program which came out last year, and it explored the underground supply and administration of Botox-type products in the beauty industry in Ireland. So that program had reference to unlicensed products being imported from South Korea, people coming in from other jurisdictions to administer Botox-type injections to clients. And also, I think there was reference to a woman giving tips about how to avoid detection by the authorities.
So that program, that investigation was carried out by the broadcasting company RTE, wasn't it? And In response to that, have any measures been implemented or proposed to regulate the cosmetic treatment industry?
So the HPRA, which is similar to the UK's MHRA, have always been carrying out many investigations. A lot of these investigations would result in corrections or cautions, so they wouldn't be reported or widely known. There has been a huge increase in the seizure of unlicensed medicines, including Botox-type products. I think in 2023, the regulator increased its detentions of Botox-type products by more than 400%. There have been many directions for the removal of the promotion of prescription-only Botox-type products. Prescription-only drugs can't be advertised in Ireland. There's also been criminal proceedings brought as well. There was a case last year which involved an Irish nurse who had a number of criminal charges against her in relation to the administration of Botox-type products. She was a former psychiatric nurse, but she was still a registered nurse. She had appealed charges regarding the supply of medicinal product without prescription, and the Botox type product she was using had UK licensing numbers rather than Irish licensing numbers, so they were not legally on the market in Ireland. She appealed these criminal charges, but they were upheld. It was also claimed that the nurse forged a doctor's prescription in order to obtain the Botox type product. In these prescriptions, she had the same date on each prescription, and they were prescribed to the nurse herself rather than clients she was administering the Botox type product to. It was also claimed that the nurse administered the Botox type product to the clients without the supervision of a doctor, which is required in Ireland. This nurse was fined in and around €10,000, and there was also legal costs on top of that.
So pretty tough sanctions then.
Yeah.
And are there any other cases you're aware of where Irish regulatory bodies have taken action against healthcare sector professionals who have been accused of various wrongdoings and misdemeanors around the supply of prescription-only medicines for cosmetic purposes?
Yeah, so the dental case, or the dental council actually got an order for an interim suspension of a dentist in order to protect the public. The HPRA was carrying out an investigation at the time. The investigation was still underway, and after the conclusion of their investigation, a criminal prosecution might be pursued. So the dental council had sought an interim suspension order in the meantime, and they actually got that. So there were allegations that the dentist facilitated the black market supply of prescription-only medicines and unauthorized medicinal products, including unlicensed Botox-type products. It was also claimed that the dentist was supplying prescription-only products without actual prescriptions, and it was claimed that the Botox-type products were advertised for sale on their website. Botox is a prescription-only medicine. You can't advertise prescription-only medicines in Ireland.
Yeah, so it's seems to me to be quite a fertile territory for legal claims and for exposure to potential liabilities for practitioners in the non-surgical aesthetics sector. As a lawyer, what top tips would you have for practitioners to help them, A, reduce their exposure to legal claims, and B, to be able to defend themselves against any claims that they do receive?
So it is illegal to supply prescription-only medication without a prescription. So there needs to be a consultation with the patient by a qualified health professional who will then prescribe, for example, the Botox-type product for use if they deem it appropriate and safe. Make sure you have a robust consent form and try to include notes of the discussion with the client. This is very important as you're usually dealing with the appearance of someone's face, and expectation versus reality in terms of what can be achieved needs to be clearly communicated and documented. As they say, no notes means no defence. If appropriate, aftercare service should be offered, and you should seek to manage any complaints quickly after treatment. Very often litigation can be avoided by having a clear line of communication with the patient and working with them to alleviate any worry or upset. Also, it is important to document any interactions with a patient when dealing with any issues. It can be a number of years before legal proceedings are issued and memories fade, so written notes are very important.
Thank you very much, Aislinn. That was really interesting and very helpful. Thank you. I'd like to move the conversation on now, if we may, to our final topic, which is to do with the care sector, and in particular, the new legislation that is currently wending its way through the process in Ireland to introduce statutory regulation of home care support in Ireland. And I understand that this is the licensing of professional home support providers bill that is currently, hopefully imminently, going to be enacted. And my first question to you around that really is this. With no current statutory entitlement to home support in Ireland, and what I understand is wide regional variation in access, please could you explain what this new proposed scheme is and how it's going to impact domiciliary carers in Ireland going forward?
Yeah, so in Ireland, there's no legal entitlement to home support services. We do have the Fair Deal scheme, which facilitates access to a nursing home. So under the Fair Deal scheme, you can apply for financial support to help pay for the cost of care in a nursing home. So a person would pay a certain amount towards the cost of care, and then the HC would cover the rest. Ireland currently doesn't have a similar scheme in place for home care. So what we have now is the statutory home support scheme. The statutory home support scheme is a proposed system for financing and regulating home support services in Ireland. When the legislation is enacted, home care providers will need to hold a licence with HIQA. They will also need to comply with the regulations and the standards. So in order to get a licence by HIQA, amongst other things, HIQA will need to be satisfied that the applicant can afford the insurance, and HIQA will need to be satisfied that with the applicant's financial capability to provide home support services. So HIQA can attach conditions to the licence, and also these licences will need to be renewed every 3 years. What is important for home care providers is that the scheme also allows for the inspection of home support service providers to assess compliance with the regulations and standards once those are finalised.
And I understand that there was quite a wide consultation process, or there has been a wide consultation process in the build-up to the introduction of these proposed regulation. And this is pretty fundamental change we're talking about here, isn't it? How has the reaction been from stakeholders to the proposal to introduce formal regulation of this nature? I mean, has it been positive, or does it vary depending on the providers? Because I would have thought this is quite onerous in terms of cost, if nothing else, particularly for smaller providers.
Yeah, so there has been support for many aspects. One of them was about having minimum qualifications for home support workers, which would improve service standards. But then on the other hand, others were having a concern that this could actually worsen existing staff shortages. Then also there were concerns that this new scheme might mean that providing home support would become inflexible. It may be costly to comply with it and cause staffing challenges. So for example, the draft regulations require individual contracts with service users, and these contracts will need to include the number of hours of home support that will be provided, arrangements for the delivery of the service, the care that will be provided, and arrangements to cover holidays and sickness and so on. So there's concerns that, let's say, if there's a last minute change of home support times or a last minute change in staffing arrangements, that you could technically be in breach of contract, which could down the road lead to litigation. So that's a concern by some of the stakeholders. Then another concern is that there will be a good bit of administrative tasks in order to comply with the new regulations and standards once they're enacted. So the draft regulations include a number of new requirements, and home support workers will need a lot of training. There'll be more administrative work. For example, the regulations list out a non-exhaustive list of 25 policies which service providers will need to draft up, for example, in relation to dementia, medication administration, risk management, consent. Some have also said that the costs of complying with these regulations in terms of training, documentation and record keeping could be very high and potentially lead to smaller providers leaving the market. A way around this is maybe using AI and IT solutions, which will ensure the efficient work practices and compliance. But this will take investment by providers and the sector. So smaller providers may not have the means for that. Also, there's a requirement for increased record keeping, and this could potentially negatively impact service users. So the draft regulations say that a personal support plan needs to be in place, and this will act as like the main record keeping document. There'll need to be a full assessment before it's in place. It'll need to include in detail the services that will be provided. And then the home support worker will need to update this document every attendance. So that means a home support worker might spend some time carrying out these administrative tasks rather than time from actually caring for the service user.
Thank you. And it does sound like, as I said, it's going to have a really significant impact if it comes in. And one of the questions that I have about it is, how is this all going to be funded? What are the most viable funding models that are currently being considered? And what would these mean for service users and for providers?
Yeah, so at the moment, home care packages are funded by general taxation. Then also service users might pay home support workers privately to get some home support. How the new scheme is going to be financed is yet to be confirmed, but we will need to know how the new system will work before we can consider how to actually finance it.
Yeah, sure. And similarly, I suppose it will have a significant impact on the workforce that is providing this care. And recruitment and retention, as I understand it, are already critical issues in the home care sector. How do you think the proposed legislation might help or hinder workforce development in the sector?
Yeah, so the home care sector is no different to many other areas of healthcare in Ireland, and they all have recruitment issues. So home support workers will now need to take more notes. So that mightn't be something which home support workers would like to do, or this might deter them. And maybe even the home support workers might look for an increase in pay in order to reflect their new responsibilities. One option to assist with this shortage of staff is for nursing homes to get involved in the sector, and their staff could provide the home care to patients. A benefit of that is that there would be a continuity of care and there would be extra income for the staff also. Also down the line, we might need to consider a new permit scheme to attract people from abroad.
Thank you. In the legislation, as I understand it, on the proposed legislation, currently excludes certain informal arrangements, such as carers who are directly employed by service users. And I'm also aware from reading into this that concerns have been expressed that this potentially creates something of a regulatory blind spot and risks creating a two-tier system, one that is fully regulated and one that isn't. Do you think that this approach to exclude the less formal arrangements undermines the goals of quality, accountability and safeguarding in the sector? Or is it your view that this is actually a sensible, pragmatic step to avoid overburdening the system?
Yeah, so the proposed regulations in their current format exclude certain situations like support provided to minors or support provided in the context of personal relationships and where no money is exchanged. And also a direct employment relationship between an individual home support worker and a single service user will also be exempt. For the moment, I think it's pragmatic. There's already such a long waiting list. I think the waiting list is around 5,000 people in Ireland. Maybe down the line when the scheme is in place, if a home support worker is working for a home care provider, they will be used to applying the regulations and all the new practices and administrative tasks. And if those home support workers move to a direct employment arrangement with a service user, they may incidentally carry over those new practices they've learned by complying with the standards and the regulations.
Yeah. That's a very good answer. Thank you. I'm conscious we've been talking for some time and we've covered 3 topics in some detail. And thank you very much for taking the time to to share your very interesting and informative views on those with our listeners. I think really just to wrap it up, Aislinn, beyond the three areas that we've discussed today, as a very experienced healthcare litigator in Ireland, what single additional change would you like to see implemented to improve healthcare litigation in Ireland in 2025?
My answer to this would probably be legal costs. The legal costs in Ireland are really high and they've been increasing. So reducing the legal costs in healthcare litigation would be very welcome. But I think these new practice directions will actually do a good job of reducing the legal costs. So hopefully come back to me in 12 months and I'll let you know.
I think we've already agreed that earlier in the podcast that we're going to come back and see how these changes, these very exciting changes, are all bedding in, and what the experience is for you guys at the coalface working with them. But that's a very interesting discussion and very helpful. And as ever with the Irish healthcare litigation scenario, it does seem to be, to me, that there's an awful lot going on, and there's a lot of changes either taking place or having taken place, and it really is a watch this space sector. So thank you for helping us keep abreast of that, and thank you again for being a guest on Altair Talks. It's been a pleasure to meet with you today.
Thank you, Will.
Thank you for tuning in. I hope you enjoyed today's episode of Altair Talks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.altairinsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented. It is provided for information purposes only. The views expressed are personal to Will Marshall and Aislinn O'Shea and are not intended as legal advice or to give rise to a solicitor-client relationship. No responsibility can be accepted by Mason Hayes and Curran or Altair for any reliance placed upon the podcast. Independent legal advice should always be obtained before applying any information to particular circumstances.